Uh, yeah, I'll just get things started. Yeah, hi everyone. So yeah, I'm Ashutosh, and today I basically run this lab called Exploration Lab at IIT Kanpur, and we work on a variety of different areas. And one of the areas is legal AI, legal NLP, which I'm going to talk about in detail. And towards the end of the talk, I will also briefly tell about other areas that my group has been working on. So yeah, the title for the talk is AI for Nyaya. So how many of you know the word Nyaya? What does the word Nyaya mean? Okay, so yeah, few of okay. So okay, for those of you who don't know the word Nyaya, so Nyaya is a Sanskrit word which means justice, right? So yeah, so this is a sort of a area where we feel that AI could help in delivering justice more efficiently and more effectively, and that's what this research is about. And I'm going to talk more about in detail. So maybe first let's get started with some motivation why we should actually look into AI for Nyaya or AI for law, right? So yeah, that's okay. Yeah, thank you. Yeah, I'll have some coffee, otherwise I might sleep during the talk. So yeah, so if you look at the statistics from India, I'm going to talk about Indian statistics because I'm from India, so I have those numbers with me. So if you look at this is a snapshot from something called National Judicial Data Grid, which sort of tracks the cases that are ongoing in the country. So if you look at the pending cases in at the district court level, this is at the various district courts in the country. So it's around like 44 million. That's the number of pending cases in the country. That's huge. That's more than population of many countries. I think it might be more than the population of Nepal, right? So, and if you look at this is at the district court level, which is like the courts at the lowest level. If you look at the cases pending at the high court, which is the next level, it's around like 6 million, which is still a big number. And if you look at the Supreme Court, which is the topmost court in the country, it's around like 80,000, which is still a very big number, right? So this sort of gives you an idea like there is a huge pendency of cases that has been plaguing the country, and this is not just India. If you look at other countries as well, the same problem is there. I mean, although the numbers might be different, but still, I mean, the problem of pendency is still there. So, and in fact, I mean, several judges from the Supreme Court, which is the apex court in the country, have sort of talked about this problem. And there was one really nice statistics which came from this was there was one judge, Justice Markandeya Katyu. He was a judge at the Supreme Court of India, and he came up with this really fun number that if you start, let's say, if you stop filing cases today and started solving all these pending cases, so it will take around 300 to 400 years to get rid of all these cases. So that's the gravity of problem we are looking at. So that's a huge number, right? I mean, 400 years is like the world would change completely, right? So uh, however, if you look at the legal systems have been established to sort of ensure that at the very minimum there's order and fairness and everyone gets justice, right? Fundamental rights are safeguarded. But with such pendency of cases, I think are we really achieving that goal is the question we should always think about, right? And I mean, there is a very famous legal maxim that says justice delayed is justice denied. And that's the kind of situation we are in right now. So, and obviously, this sort of warrants that there should be some way of expediting the judicial workflow and the associated processes, right? And when we talk about that, then one thing which comes to our mind is the AI God, or at least some people call it God, right? So AI has had a huge impact in almost all the areas. I mean, and the fundamental technologies in RL, machine learning, deep learning, NLP, and so on and so forth, LLMs, right? They have impacted each and every area, every aspect of life. I mean, you take any field, it has been impacted by these technologies. And one particular area like NLP has a sort of revolution over past few years, right? Ever since like Transformer came and then later on LLMs came, it completely revolutionized and changed everything that was out there. I mean, you have really good systems for email, handling emails, and then chatbots and smart assistants are there. Document analysis systems are there, right? I mean, summarization and translation and all sorts of things are there. So and all these technologies are quite mature. I mean, they in some cases they are better than humans, right? So so now the question is, okay, we have really good mature NLP technologies and we have off-the-shelf tools available with us. So why can't we directly use them for processing legal text? I mean, legal. I mean, in legal domain, the main modality is documents, right, which are in form of textual text basically. So why can't we just adapt? I mean, or why can't we just directly use the pre-trained models or NLP tools and various things that have been developed for legal text? I mean, so we will look at this question first, and then we'll see what could be done. So at the fundamental level, there are certain differences between the legal text and the usual text that has been used to train the let's say the LLMs or the other NLP tools and models, right? So first of all, like the legal text are sort of very different in the sense that these are super long documents. I mean, I don't know how many of you have seen like legal judgments. They can span like hundreds of pages at times, right? Tens and hundreds of pages is fairly common in legal documents. So the models which have been trained, like for example, the BERT model might be trained on, let's say, much smaller documents, right? And they might have a finite context length. So they would struggle to handle these kind of long documents, because what will happen in these long documents is that you might be mentioning certain things in the beginning of document, and maybe later, maybe let's say 40 pages later, you might refer to the things that were mentioned in the beginning of the document. So that kind of association and sort of keeping track of things is really important, which is really, I mean, which the conventional NLP models sort of struggle with. Then the other challenge is that, and which many of you might have guessed, like legal domain, the lexicon is very different. The kind of legal language that is used is very, very different. I mean, I don't know how many of you have seen legal documents. I mean, the document might be in English, but it still looks like a different language, right? It's very hard to interpret those things, and that's why you have lawyers, right? I mean, they will charge you per hour, and this is the reason they charge you a lot, right? So, so if you have a conventional NLP model, it will not be able to interpret these terms and words correctly, because a word which is in English might have a very specialized meaning in the legal parlance. So that association and that context has to be taken into account while processing these legal documents. Then the other issue, particularly which is relevant for the Indian setting, is that these documents are sort of quite unstructured and at times very noisy. So what happens is, like when let's say the proceedings are going on in the court, there might be a clerk who would be sitting in the court and they would be sort of taking down the things and typing it and putting it into text. And obviously they might introduce errors, there might be grammatical mistakes, spelling mistakes, and all sorts of things might come into there, right? And also the document, if you look at legal document, these are just like paragraphs. There's no any subheading or any sort of topical annotation or labeling of different parts of the document. So which makes it sort of very hard to sort of process, right? And you don't know which part of document is talking about what. It's like complete full text which is out there. Then the other challenge with legal domain is, like, legal domain is vast. I mean, there's not just one law, right? I mean, there are several different kinds of law. Like, for example, you might have laws related to civil cases. There would be laws for criminal cases. Banking might have its own laws. Insurance might have its own laws, right? So there's several kinds of laws, and so the underlying general underlying legal principles might be similar across these different laws, but when you go into more depth, they are quite different, right? And in fact, laws might differ significantly across sort of domains, right? Like banking laws might have nothing to do with, let's say, sort of laws that might be made for, let's say, traffic traffic violations, right? So those are kind of very different. So the models would need to have sort of good generalization capability is one thing, but also they should be able to handle some sort of domain shift which might take place. So for example, if I develop a model for, let's say, civil cases, now if I want to use that model for, let's say, banking and insurance kind of cases, then you need to do some sort of domain transfer, right? And that itself is, I mean, a field on its own in machine learning, right? Like, I mean, domain adaptation as it is called, right? So those kind of things have to be there. The model should be, I mean, your model should be able to adapt to a new domain as and when it comes. Then the other important thing with legal domain is that explainability is sort of not a second class citizen. So typically in machine learning, when you develop models, you develop the model and you try to sort of have a really good performance. And then later on you realize, oh, maybe I should also explain the decision, right? Like especially with deep learning models, right? But in legal domain, the explainability has to be part of the model development process itself, because this is important, because these models or these systems are going to be used by lawyers or judges, right, or any legal practitioner, and they would like to know why the model came up with a particular decision or why this outcome was there, because if they don't understand why this decision came, they will not trust the system, because sometimes what might happen is that the decision might be contradictory to what they were thinking, although the line of reasoning might be correct and might be different from what their line of reasoning was, but they would not trust because they might think it's just an error in the system. So they would appreciate if the system was explainable, and that's where the trust part comes in. They have to they can only trust if it's explainable. So explainability is a first class citizen in when it comes to legal models, right? So that's another constraint and another important feature that has to be there. And then finally, the laws are sort of very region specific, right? Like, I mean, the laws which have been developed for the, let's say, EU or US would be very different, significantly different from what we have in, let's say, India or Nepal or any other country, right? So if I had, let's say, someone developed a LLM for EU cases or US cases, if you try to use that for Indian setting, it doesn't work. It fails badly. And I mean, later on, I'm sure that we had tried such experiments, and you would need models which are sort of specific to certain regions. And in fact, particularly in India, what happens is like different states. I mean, India has sort of a federal sort of structure, right? So you have federal laws or central laws, and then you have state laws. So state laws also vary from state to state, right? So that's another challenge that happens. Like if I develop a model for, let's say, one state, then it may not always work for the other state because the law might be sort of different. So that again, this is sort of again related to sort of model adaptation, right? I mean, you want to domain adaptation, so you might want, let's say, you have developed a model for one particular region. Can you do some sort of domain adaptation to a new region, given certain laws for that region, right? So these are uh, sort of the features or the challenges that are associated with the legal domain, and that sort of I hope that convinces you that we need some sort of different kind of tools and technology for processing and understanding legal documents, right? And that's what talk is going to be about. So before I go into any specific tools and models and technologies, I will like to sort of point out certain bottlenecks which prevent us from developing these tools, and why we still don't have really good state-of-the-art tools or models for the legal domain. So one of the biggest challenge with legal domain is that there is sort of lack of high quality large legal corpora. So, and this is particularly true for the Indian setting. Like, I mean, in India, like the documents, I mean, traditionally the documents have not been digitized, right? So, you don't have enough data to train any model, and especially nowadays, most of the models are data hungry, right? So you need huge amount of data to train models, and that is what is lacking. I mean, and in fact, what also happens sometimes is that, and this is particularly true in India, is that they might have digitized document, but these digitized documents are not machine readable, which means that they might be, let's say, scanned documents, which will create some sort of image of the document. So now you need to apply additional step of OCR, optical character recognition, to extract the text out of these documents. And obviously OCR will introduce its own errors, right? I mean, it's not perfect. And especially like if it's a language different from English, then yeah, I mean, there are going to be much more errors. Then the other challenge is that, okay, if I want to develop some sort of a machine learning system, or many times I would need some sort of supervision, right? So for that, we need some sort of annotations to be done in the document. And annotating legal documents is not that easy, right? I mean, you cannot upload a document onto Mechanical Turk or Prolific or any of these crowdsourcing tools and ask people to annotate. You need specialized people, right? You need lawyers to annotate. And you know, lawyers charge by hour, right? So annotating legal documents is really expensive. I mean, you can get bankrupt if you try to annotate a large corpora, right? So this is another challenge. You have limited supervision. How do you develop models in this limited supervision and low resource kind of setting, right? So that's the other bottleneck. And then if you look at conventional NLP domain, so you have like standard tools, like I'm sure everyone would have heard about Spacey and NLTK and all these tools, right? Which can do the low level stuff with the text, right? Like, I mean, extract maybe named entities or do co-reference resolution and part of speech tagging and all those low level stuff they can easily do. So whenever you want to build an application, you don't have to struggle with these low level stuff, and you just pass it through one of these toolkits, and then you sort of, have some sort of information extracted, and then you can build your application on top of that. But in legal domains, such low-level tools or maybe toolkits don't exist. So if you want to develop an application, you will have to start from scratch. So you first need to sometimes even tokenization can be a challenge in legal domain. So first you need to develop a tokenizer, and then maybe if you want to do, let's say, named entity recognition, then you will have to build that, and then co-reference resolution. So it's sort of reinventing the wheel every time you want to do something new. So if there were certain toolkits, then obviously your life becomes easier. You directly use these toolkits to sort of process the text, and then you can start building the application that you want, right? So this is sort of lacking, right? Then the other challenge with legal domain is that there is like if you look at the NLP field, right? I mean, it has evolved over several decades, and people have built specialized resources such as knowledge graphs and ontologies, which sort of captures the domain knowledge, right? And it helps in several applications and use cases. But in legal domains, such ontologies and knowledge graphs are not there. So which sort of is sort of challenging, right? Because you are lacking the domain knowledge in that sense. So you're building a model, and obviously you're not a lawyer, but you don't know the law, right? So if your model is doing something wrong, then it's hard for you to sort of find out, like, okay, what's going wrong? Or if I could have some sort of priors in my model with regard to the domain knowledge of law, then it also will obviously improve my model. So that sort of domain knowledge is sort of in structured format is lacking. And then the other challenge is like, okay, there are these general LLMs, right? I mean, all of you, everyone is aware of these. But if you look at domain-specific LLM, there are very few legal LLMs, right? And those which are there, they are specialized to certain regions, like, for example, maybe EU or US, right? For countries like India, Nepal, which have sort of a kind of a low resource setting, as I mentioned earlier, they don't have a really good LLM. And as I said earlier, that if you try to use the LLM from, let's say, EU or US, it doesn't work well for the Indian setting, right? And if you try to use GPT for Indian setting, it again fails. And I'll show that later as well. And then the other important thing is that legal domain is lacking benchmarks. So I know, I guess everyone knows about computer vision and ImageNet, right? So everyone knows about ImageNet? Okay, so is anyone who doesn't know about ImageNet? Okay, so ImageNet was like a sort of a very, I would say, a very crucial movement in the development of computer vision systems, because ImageNet, what ImageNet did was it established a benchmark which sort of motivated the research community to develop better and better models, which will improve vision systems, right? So benchmarks are really, really important, because they sort of, first of all, obviously it helps you to assess your model reliably. That's one thing. but also it sort of encourages some sort of healthy competition among the researchers to develop better and better, right? So let's say I put my model into the benchmark and it gives certain performance, then there might be some other researcher who would try to get a better performance out of the model, right? For that particular task, right? So these benchmarks are really, really important, and they sort of push the field forward. And legal domain, we are sort of, we are lacking these benchmarks, and that's why sort of, field has also not progressed as much as it could have, basically, right? So that's another bottleneck. And then the one of the biggest challenge which I see is that, so you have people working in the legal tech, and then you have lawyers, and both of them don't talk to each other, right? I mean, lawyers don't trust technology, and technologies don't trust lawyers. So it's sort of a deadlock which happens, and because of this, obviously the domain transfer doesn't happen, and obviously it sort of negatively affects the field, right? So what we sort of need is both of them need to come to the table and talk to each other and develop the things together, because ultimately what we are doing is we are developing for the society, right? I mean, it's for everyone. It's not just for researchers. I mean, we are not developing models just for beating some benchmark or impressing or writing a good ACL paper, right? I mean, we are building at the end of the day to actually help the society. So, and for that to happen, you need people who understand the society or who understand the underlying system. So, and obviously lawyers are the experts in that. So you need them, and obviously lawyers don't have the technical expertise, so they need technical guys to, or technical people to sort of develop the things that they would like to see in the legal system, right? So that sort of dialogue has to happen, and it has slowly started now, but still, I mean, it's a long way to go. So these are sort of the bottlenecks, and I'm now later on I'm going to talk about how we have been addressing these bottlenecks to move the field forward, and various research that we have done in some of these areas that I just mentioned. So before I go there, I will talk about some of the typical use cases in the legal domain, like different tasks that are typically common in the legal domain. So one of the tasks in legal domain, which can also help in handling the pendency of cases, is legal judgment prediction, right? So you want a system which could give the outcome of a case, or at least give a recommendation about the outcome of the case. Then that is going to be really, really useful, right? I mean, because I earlier showed that there are around like 44 million pending cases, right? So you need something which can expedite the things. Then there, as I mentioned, like legal documents are usually super long, right? And if you could have some sort of a system which could semantically segment the document into topically coherent units, then that is going to be very, very useful, right? Because then you know which part of the document is talking about what. Let's say it could tell which part of the document is about facts, which part of the document is about the arguments. So that information is there, then it can help in downstream tasks, right? Like information extraction or reasoning and all kind of things, right? Then another task is something called prior case retrieval, where let's say typically what happens in a legal judgment is, when let's say a judge is writing a judgment, they usually cite a prior case or a precedent, right? So conventionally what they have done is they've relied on their experience and memory to cite the prior precedents. But obviously, as the number of cases has been growing, this problem becomes really untractable. So if there was a system which could sort of recommend the citation or what possible prior cases could be there, which could be cited, then that is going to be really useful, right? And same for the statutes as well. Like, let's say I give certain factual situation. If the system could tell me which particular laws or statutes or particular sections of the laws are applicable in this particular setting, then that is also going to be very, very useful, right? And then one obvious application is like legal documents, as I said, are super long. If you could have a system which could summarize the document, then that is going to be really useful. The other task is something called argumentation mining. So if you look at a legal judgment document, it involves sort of two parties coming together and arguing about the case, right? So that there is some sort of argumentative structure which is there in the legal document, and this argumentative structure actually contributes towards the final decision that the judge is going to take, right? So if you can sort of extract this argumentative structure and sort of understand this, then this could be useful for decision making. So this is what argumentation mining is about, extracting this argumentative structure and then trying to use that for reasoning and coming up with the decision of the case, right? So that is what the task of argumentation mining is. And then there are standard tasks like information extraction and retrieval, where you might want to retrieve certain kind of information from, let's say, a huge number of legal documents, right? Or extract certain information. So those are also there. So these are some of the use cases. And obviously, this is not an exhaustive list. I mean, these are just some of the use cases. There could be several other use cases which could be out there. So now I'm going to talk about the specific research that we have been doing, that my group has been doing in the legal domain. And this sort of tries to address some of the bottlenecks which I mentioned earlier, and also sort of is related to the use cases that I just mentioned. Right? So any questions at this stage? Yeah.
A lot of the times in legal settings we try to create new precedents. So cases which are extraordinary and things like that. So how, if we are using NLP based methods, say for example, scope of making a precedent then decreases. So how
Why does it decreases?
generally, like alimony case for example, I'm not exactly able to remember the name, but that is the first time. Before that, there was no precedent for it.
Okay.
If we were to a systematic system we are able to design here, then how are we able still keeping a scope for humane part of it and allowing people to create new precedents and
Yeah, in fact, what I feel is it will increase the chances of creating new precedents. The reason being that, okay, let me first give you an analogy, right? So you know the game of Go, right? Go, right? I mean, DeepMind built a system for playing the game of Go, and it has beaten the world master, right? And in the game of Go, what they realized was that the system was able to come up with some really nice moves which no one had thought before. It was able to sort of reason around that, and so something similar could also happen in legal setting, where I mean, we are still far from doing that, but I mean, if I mean, in future when the AI gets developed fully, that it should be able to reason in a different line of thought compared to, let's say, a human, and that reasoning would be correct. I mean, it would be following some sort of logical order, at least would be following the legal logical order, and but it would be something which no human might have thought before, right? So that could create a new precedent on its own. This is with the assumption that AI is mature enough. We are still far from that, but that's the vision we have, right? At some point it will be there. All right, any other question? All right, so by the way, if anyone has any question in between, please raise your hand and feel free to ask. We can keep the session sort of interactive. All right, so now I'm going to talk about a particular research that we have been pursuing. So the first one is something called ILDC for CGP, which is like court judgment prediction and explanation task. So the motivation is sort of, something which I already mentioned, that like countries like India has a huge backlog of pending cases, right? Like I told you, like there are around like almost 50 million pending cases in the country, right? So we need something which could sort of expedite the process. And so there is a word of caution here. I'm not saying that I'm building an AI system which will replace a judge. That's not the motivation, and that will not, at least next, I don't know, next few years it's not going to happen. So what I'm saying is that we want a system which will augment a judge to make sort of quick decisions. It will sort of provide recommendations. It's up. The final decision has to be taken by the judge. I mean, they accept the recommendation or they don't accept. It's up to them. And so for that to happen, the system should not just make the recommendation or the final decision, but it should also explain the decision, why it came with this particular decision. Then only the judge or any legal practitioner is going to trust the system, right? Otherwise, I mean, why would they trust a black box, right? I mean, it's just outputting certain outcome, right? So the system has to be explainable as well. And that's what brings us to the task of code judgment, prediction, and explanation, CJP as we call it. So the task is as follows. So you're given a legal document, and the AI system is supposed to give the outcome of the case. So whether the appeal is accepted or it is denied, right? And this is the prediction part. And then, as I said, it should also explain the decision why this appeal is accepted or it is why is it denied, right? So that's the explanation part. So together these constitute the CGP task. So that's the task definition that we have. And then, so for this task, what we did was we had to sort of start from grounds up. I mean, there was nothing out there before. So we started with creating the corpus and sort of having the annotations in the corpus. And we had to sit down with the lawyers, a team of lawyers, to sort of evaluate the things. And then we developed certain models for doing both the prediction task and the explanation task, which I'm going to explain next, right? So for the corpus, we call it ILDC, Indian Legal Document Corpus. So what we did was we mainly focused on the Supreme Court of India cases, which is like the apex court in the country, and there's a website called India Qanun, which has all the case documents from Supreme Court and even the High Courts. So we extracted, basically scraped the website, and we got this data, and it's all publicly available data. So I mean, there's no sort of any privacy sort of issues there, because most of the, I mean, almost all the Supreme Court cases are in the public domain, right? So it's open to anyone. And then what we did some pre-processing and sort of extracted the meta information. And so a judgment document also has the final outcome. So obviously, if you are developing a system, we want to remove that part of the document which has the outcome, because that's what we want to predict in the end, right? So, and that outcome actually is the gold label for the case, right? So we sort of using pre-processing and certain heuristics, we sort of extracted the outcome. So now we have sort of data where we have a case with facts and arguments and issues, and then the label whether the appeal was accepted or denied, right? It's sort of the binary label. And this sort, as I said, this gives the gold labels for each of the case. And then so what happens in Supreme Court is that sometimes, usually there would be a single appeal which is filed in a case, and that's what we call as ILDC single. But many times there will be multiple different appeals in the same case. In the same case, you might have multiple appeals being filed. So in that case, obviously, multiple decisions are going to come out. So in this, so this part of data set we call as ILDC multi. So because you have multiple appeals out there, right? And then another thing that we did was we also we took the ILDC single cases and we gave it to experts. By experts, I mean the lawyers or law graduate students, essentially. And we asked them to sort of do two things. One was also give the outcome of the case. I mean, they didn't know the ground truth, so they were in the same situation as a model. That's one thing. And we also asked them to explain the outcome, why this particular, why they gave this particular decision. And the explanation was in terms of the important sentences in the document that are leading to that outcome, right? So that was the sort of the explanation part, and that's what we would like the models also to do, right? So this gave us the this ILDC corpus and like different sort of versions of it, and they were around like 38, almost 38,000 documents in this thing, right? So what we did, I mean, while creating this corpus, we need to take care of few things. I mean, you cannot just use the things as it is. And as I said, like we divided the data into, like in any typical machine learning setting, into train, development, and test set, right? So for the train and test validation, train, test, and validation split, we did not do any temporal splitting, which means that I did not take, let's say, cases from 1950 to, let's say, 1990, for example, as train, and then next 10 years as validation, and next 10 years as test set. We didn't do that. We sort of mixed it and randomly divided it into the splits. And the reason being that we want the model that is being developed should learn sort of the features which are relevant for the laws and and are based on the facts rather than any temporal clues which might be which might be sort of giving some sort of spurious correlation between the outcome and the content of the case, right? So we wanted to avoid all those kind of things, so that's why we just randomly split this thing. The other thing was we also didn't focus on a specific kind of law, like we didn't focus on criminal law or civil law or anything. We again did a sort of a random mix of all kinds of different cases that are there in the Supreme Court. And then the final thing that we did was we anonymized the name of the judges, appellants, petitioners, all these, right? Because what has been observed, and that's what also there was a law professor who also worked with us on this in this research project. He told us that there is a very strong correlation between the judge name and the outcome that is going to come, right? So in fact, I mean, people have sort of hacked the system. They know if this case is going to this particular judge, what the outcome is going to be. And I mean, people have built a company around it, which will sort of try to select the judge for you based on the case that you have, right? Which is sort of not a good thing, but I mean, that's how it is. So we wanted to avoid these kind of biases in the data set. That's why we anonymize the names of judges particularly, right? So this sort of gives us the ILDC data set. And then as I said, like we had the law experts, like they were 5 experts, and these are like law graduate students and a law professor. We asked them to give the outcome of the case, and we evaluated their outcome with regard to the ground truth, which is the original outcome given by the judge of the Supreme Court. So the interesting thing to see here is that none of them is 100%, right? So the lawyers, so the best you are getting is around like 98%, right? So that means that there is, yeah.
What is the outcome? Is it binary?
Yeah, it's a binary, whether the appeal is accepted or it is denied.
So did you consider like any scales?
No, so we did not consider the scale because the ground truth is binary actually, and we don't have anything in between, and that's how the court gives the decision. So so the thing to note here is that lawyers don't agree with each other, which is I mean well known, right? Lawyers never agree with each other. So if you have 6 lawyers in the room, you will have 12 different decisions, right? So but here you can see it's quite a difference there, right? And which also tells that there is a lot of subjectivity which comes into play, because the thing is the main challenge in law is how do you interpret law. I mean, for the same text, I can interpret it in a different way and I can have a different outcome. So the interpretation of law is the thing that's what the model is also going to struggle with, right? So this, as I said, like there was not agreement among the lawyers, but yeah, I mean, if you calculate some sort of Fleisch-Kappa sort of inter-annotated agreement, it is quite high. I mean, and what we saw was that, as I said, like the differences in the decision were coming because of the linguistic interpretation of the text. I mean, different experts were interpreting it differently, and that's why you were getting different outcomes. So this, and those of you who are not lawyers, this interpretation of law is actually really, really important, because for the same case, you can have a completely different outcome if you could interpret it in a different way. And that's what lawyers charge for, right? I mean, law is out there, it's in the public, but how do you interpret that in a different way so that it is in your favor, right? That's what that's why the lawyers, the good lawyers actually are able to interpret in a way that might work in your favor, right? So that was the prediction by the experts, and then we also asked the experts to do the explanation annotation, explain the decision, right? So if you sort of compare the decision across the experts. Like you have 5 experts here, like user 1 to user 5. You can and yeah, these are Rouge score. Each expert gives an explanation, and you compare the explanation using a Rouge. Rouge is like a stand. I guess everyone knows Rouge score, right? Blue score, Rouge score, which is used in sort of machine translation and summarization to compare, let's say, a ground truth text with the text which is generated by the system. So we compare two kinds of text here. I mean, we compare text between uh, the uh, the explanation text which is given by different experts, right? So here again, then the explanations are quite different. And so what we saw was that expert 2 and expert 5 were doing some sort of bare minimum reasoning, but expert 1, 3, 4 were considering doing some sort of holistic reasoning. So even there's a lot of variation within the reasoning itself, right? So that's another sort of challenge there. And then we obviously develop models for doing this. So I mean, these are like a small snapshot of models. There are lots of other models. I mean, I'll give the link to the paper. You can check out details. So we tried out several different models, and the best we were getting around was around 78% F1 score, or around similar 78% accuracy, right? So this and this was XLNet plus ByGru kind of model, right? And compare this with the average average expert accuracy, it's around 93%. So there is a huge gap. I mean, lot of research needs to be done, right? So yeah. So this was our best model. So the architecture is as follows. As I said, like the legal documents are super long. So what we did was we chunked the documents into segments, right? And each of the chunk goes as input to a XLNet model. So everyone knows transform. I guess you already had a lecture on transform models, right? Like XLNet and BERT and all these models everyone knows, right? Is it a yes or no? Okay. So yeah, so we give this XLNet is kind of similar to BERT model. So you give input to the each of the chunk goes as input to the XLNet, and then you get you use the CLS embedding from each of the XLNet, and then you apply some sort of a ByGru on top of that, and then you aggregate that decision to get the final outcome. Right. So that was the best model that we had, and then for doing the explanation, what we did was we used something called a occlusion method. So the idea, the intuition here is that, let's say I have the text which is given as input to the model, and it gives certain likelihood of a decision. So if I remove certain part of the text, let's say I remove a sentence, I would like to see what is the change in the likelihood. If the likelihood sort of drops down, that means very likely the sentence was important in making the decision, right? And if it doesn't drop down, then sentence is not relevant. So that's the intuition behind occlusion method. So what we did was we remove a particular sentence and see the change in likelihood. So we have two levels, right? One is the chunk level and one is the sentence level. So you can do it at both the levels. You can do it at the chunk level, remove a chunk and see what's the change in likelihood, and then within the chunk you remove the sentence and see the change in likelihood. So that can help you to give the important sentences that are leading to a particular outcome, right? So that was the explanation part. And then we compare the explanation of the model with respect to the experts. Again, there is a huge difference here. I mean, these are like different metrics that we used. If you, let's say, look at the Rouge score, I mean, Rouge score is not that high if you see across all the experts. So then again, it's not just the decision making which is very different between humans and model, but also the explanation which is different between humans and model, right? So a lot of scope for improvement. So to conclude this part, I mean, we sort of developed this corpus and formulated this CGP task, and then we show that there's a big gap between the two, between the humans and the model, and more research is required in this area. So if you're interested in the dataset and the models and the code, everything is out there. It's open. I mean, it's an open. So we have made everything open, so you can sort of download it from the GitHub repo. All right, so that was the judgment prediction. So now I'm going to go to the second research direction that we took. This is also kind of related to the judgment prediction, but this is more sort of specific to the Indian setting. For the ILDC, the documents were in English, right? Because these were from Supreme Court of India. So in India, the Supreme Court and the High Court both works in English. The official language is English, so all the documents are in English. But the district courts in the country are in the regional language. I mean the place where this particular district court is, they will be using that regional language. So what we, as I mentioned earlier, the the maximum number of pending cases are at the district court level. So we need to do something about that, right? So as I said, the other challenge is that the documents are in regional language. It's not English. So you need models which are able to handle some other language. It could be even a low resource language, right? And obviously, if you use an English model, it won't work, right? The language is different, terms are different. So what we did was to address this, we developed this HLDC, Hindi Legal Document Corpus. We focused on Hindi language because that's one of the prominent languages in the country, like particularly northern part of the country, right? And this was around 900. I mean, we created a corpus of 900,000 documents, which is a huge corpus, right? And then we formulated a task of bail prediction on this corpus. So I mean, I guess everyone knows what's a bail is, right? So so I mean, I will show later. We develop a multitask learning model for solving the task of bail prediction. So this is sort of the pipeline. I mean, I'll not go into too much details. Basically, we got data from this eCourts website, and then it's sort of scanned documents. So we had to do OCR, get the text, and did some processing of that, and then we got the HLDC corpus, and then from this we sort of formulated this task of bail prediction. And the reason for task of bail prediction is like we scraped the documents from this a particular state in the country, which is called Uttar Pradesh, which is like the northern part of the country, right? And if you look at the ratio of the bail cases to the other cases, it's very high. So the most of the pending cases are actually the bail cases. So that's why we targeted the task of bail prediction. And then yeah, we created the bail corpus. And so what we in the bail documents, what we did was we extracted the decision, which is the ground truth or the gold labels, but we also extracted the judge. So usually in a bail document, the judge will also give an explanation why they are denying the bail or they are accepting the bail, right? So giving the bail basically. So we extracted that part as well from the document. And so the task is that given the facts of the case, goal is to predict whether the bail should be granted or denied. Essentially, it's a binary task again, right? You want to learn some sort of distribution over outcome given the facts, right? And it's 0-1 sort of decision. And this is the sort of the model that we developed. Since the documents are in Hindi, so we used multilingual BERT. So we did two things here. It's a multi-task kind of setting where we predict the bail outcome, but at the same time, we had something called a salience classifier, which were predicting the important sentences that would lead to a bail document, or that will lead to the bail decision. Sorry, right? And these you can compare with the judge's summary or judge's opinion. So we have the loss function has two parts. One is the bail prediction part and the saliency part. So together these two sort of form the multitask learning setup. And then we did various kind of, I mean, you can check out the details in the paper. We tried out various models, and the best we were getting was around 78%. And we also tried like district-wise and all districts combined together, different kind of settings. You can check out the details in the paper. Then sort of to conclude this part, I mean, we need models which are able to handle regional aspects as well, regional language and colloquial terms, basically. And that's what we tried to do in this task, right? And we developed the system for predicting the bail outcome. And again, everything is open. You can check, you can download the data set and everything. Okay, so now going to the next. By the way, any questions so far? Okay, so now we'll go to the next part. As I said, like, I mean, legal documents are super long, right? So if you look at this particular, I think this is from a Supreme Court of Supreme Court of India, and if you see, it's like a big chunk of text. So if you had a system which could sort of semantically segment this into topically coherent units. So for example, it could tell, okay, this part of the document is, let's say, the preamble. This is the facts of the case. These are the arguments, and these are issues, and so on and so forth. Then that system is going to be very useful, right? So this is what we try to do. So each of these different parts are called as rhetorical roles, right? So essentially we have like 30. We had 13 different rhetorical roles, which are like facts of the case, ruling by lower court, arguments by respondent or arguments by petitioner, issues, statute, uh, precedent, ratio, dissent, ruling, right? And in addition to these, we also had a none label, which means none of these of the other apply. So the task of rhetorical role labeling is that segment the document into sentences and label each sentence with one of these rhetorical roles. So that's the task we are looking at, right? So, and obviously this can be useful for various applications like prior case retrieval, summarization, even judgment prediction, and those things. So in this, we first of all created a corpus. I mean, you will see throughout all the research that we are doing, we are almost starting from scratch every time because nothing exists there. So we are actually building it from grounds up. I mean, sort of, which is sort of good in some ways because it gives you the opportunity to define the field itself, right? So, but obviously it's quite challenging because you have to create everything from scratch. So we created the corpus, which is annotated with rhetorical roles, which means every sentence is annotated with one of those roles. And then obviously we also develop some models for automatically segmenting the documents, right? So we particularly focused on income tax and competition law cases, right? And then we had 6 legal experts who annotated the cases with these rhetorical roles. And then and we measured the annotator agreement and all those things, and it was sort of in a high agreement region, right? So the task is like you're given a document. For every sentence, you have to label uh, one of those 13 rhetorical rules, right? I mean, which I just mentioned. So it's sort of a sequential task. I mean, in some ways, it's a sequential because you go sentence by sentence and you start labeling each and every sentence. So we experimented with several different models, and the final model that came out was actually based on one intuition. So the intuition is what has been observed is that rhetorical roles, if you look at a legal document, the rhetorical roles don't change abruptly, and they tend to follow some sort of a order among themselves. So usually you will have facts of the case followed by ruling, followed by arguments, and so this is sort of a pseudo order that is usually there, but I mean it's not a hard and fast rule that it will always be like there. So what we try to do is we try to make use of this intuition, try to make use of this label inertia. I mean, and rhetorical rules won't change abruptly. They tend to maintain certain inertia. So what we try to do is we formulated a auxiliary task of label shift prediction. So the task is that for each sentence pair, let's say you're given 2 sentence pairs, contiguous sentences in the document. What you try to do is you try to predict whether we want to change the label. Let's say first sentence had the label facts. Would the next sentence also have the same label, or the label would change? So a binary decision. So we formulate this as a auxiliary task along with the main task of predicting label for each and every sentence, right? And so this leads us to one of the models which is called which was based on Siamese network kind of architecture, where we want to predict the label shift prediction along with the rhetorical role prediction task. So the idea is that you are given these, let's say you have these sentences Si minus 1, Si and Si plus 1, like 3 contiguous sentences. You try to predict 2 things. One is whether you shift the label between the first 2 sentences and the next 2 sentences, and these 2 are sort of same network. These are Siamese network, right? And then obviously you also predict the rhetorical role of the sentence in focus, which is Si, right? And you combine these and then you apply some sort of a BiLSTM followed by a CRF on top of that to do, because you are doing a sequential prediction, right? So you predict at each and every sentence. So this was one model. And then another model that we uh, have was multitask learning model. So here the idea was that you have two components, the auxiliary component and the main component. The auxiliary component is the shift component. So idea here is that you have these sequence of sentences, right? These sequence of sentences, and then you pass it through this network which has these E is the embedding, and then you have some sort of BiLSTM, and then CRF, and then what you do is you predict yi, which is binary label 0 and 1. The shift task that I mentioned, right? Whether the label should change or not change, which is 0 and 1. You predict that, but this is the auxiliary component, and in the primary component or in the main component, you predict the rhetorical role label itself, right? So, but what you do is the embeddings that you are learning from here, from the auxiliary component, you also provide that information to the main component or the primary component, because the intuition is that the shift information should tell the main model whether to you change the rhetorical role or you keep the rhetorical role same, right? So it sort of drives the main model in some way, right? And that's how you sort of predict this thing. So this is sort of the multitask learning setup we have. Any questions on this? Or all right. So once we had this, we sort of, I mean, we experimented with several different models, and obviously the multitask learning model was giving the best performance, right? I mean, uh, it was around like 70% F1 score. I mean, and all these details are there in the paper. And yeah, so as I said, like rhetorical role labeling is a very important task, and because I mean, it provides a way to handle long documents, right? And we made use of this label shift information to sort of to develop a better model, which was a multitask learning model. And again, everything is sort of out there, data set and model code and everything, right? All right. So yeah. So I'll move to the next part. Any questions so far? Yeah. Mm.
So, you mentioned in the beginning that it's very difficult for the lawyers to use any new systems that you're implementing, and I'm wondering if you managed to use at least the one that you just talked about, because I feel like it's quite useful for them to have summaries of all the documents, for example. Yeah.
Yeah. Actually, you have a good question. So yes, I mean, what we are developing is sort of useful for them. So the judgment prediction thing, we haven't deployed it because it's sort of a very sensitive task, right? You don't want to put something which has not been thoroughly tested. So that part is still sort of in under sort of more of testing. But other things like rhetorical role labeling, and later on I'm going to talk about this prior case retrieval and all these things. These are actually, we are working with one of the governments, one of the state governments, to actually implement these into their system, and these are going to be used by the lawyers and the judges there. Yeah, yeah.
So like in this project, we talk about a lot of benchmarks. So like all the benchmarks were quite deterministic in nature. Like for example, basically they did not focus on the semantic interpretation. That is, you mentioned about the interpretation part.
Yeah.
Like lawyers utilize the interpretations in different cases
Hmm.
for in favor of their particular clients, right? So don't you think there's a
No.
requirement of
Wait. Why do you say that the tasks are deterministic?
No. So I mean to say like the benchmarks there are. So they like, for example, the blue score, the root score, they are like they match deterministically and do not have a semantic relationship. Like let's say there are, if you want to match two different texts, so there is not a semantic similarity relationship.
No. So okay. So there are two different things. One is the evaluation metric. One is the task itself.
Yeah.
Right. So task is not deterministic, because I mean, as we saw, like lawyers can come up with different decisions, right, and different explanations, which is sort of interpretation. but on the metric side, we don't really have really good metric to actually measure the semantic interpretation, right? So that is sort of still an open area of research. How do you actually measure two pieces of I mean, you can use things like bird score and those things, but those are still not perfect, right? So I mean, we don't know what would be a good metric to actually measure the semantic interpretation of two legal pieces, two legal texts. So I mean, that's sort of still open to sort of research.
Oh, okay.
Any other question? All right. So now let's move forward. So now I'm going to talk about. So far we have seen. I mean, okay, we have seen the decision making part and then sort of semantic segmentation part. Now we are going to move towards sort of more information retrieval kind of part. So the idea here is that, as I said earlier, uh, I mean, lawyers and judges usually use their experience to sort of cite the relevant precedents, right? And obviously, I mean, as the number of cases have been growing, this is sort of becomes sort of a very difficult task, right? So the task of prior case retrieval, as I also mentioned earlier, is to automatically retrieve all the previous legal documents that should be cited in the current legal document based on the factual and precedent relevance. So, I mean, formally given a query document queue and a candidate pool of documents, retrieve the candidate which are relevant to the query, right? And one thing to note here, I mean, you would also have seen these kind of tasks in regular NLP domain, right? I mean, like search engines and those things. Here, the relevance has a different meaning. I mean, in regular NLP domain, relevancy usually is sort of semantic similarity, but here relevance is more in terms of the factual situation and the previous similarity between the previous legal precedent, right? So it's slightly different from the regular NLP thing. And as I'll show, if you just use standard NLP retrieval models, they don't do well in this task, right? So as I said, like you have a query document, right, which has these citation markers are there, right? I mean, these are sort of masks, right? And you want to predict which of the cases should be cited for this mask, for example, right? You have this. I mean, you can see. I mean, we have anonymized the names and those things, but the main thing is what citation should go here among the candidate pool. So that's the task, right? So yeah, again, I mean, we start from scratch as always. So we create a data set for this, and then we solve that problem, right? So we created a new benchmark. So this is we had like around query pool of 11 almost 1200 documents, and then candidate pool of around 6000 documents, right? And then we create a system called Euclid, which I'm going to talk about later. So if you compare, COLI is a existing data set for the Canadian setting, Canadian legal system. And ILPCR is Indian legal prior case retrieval data set is our thing for the Indian setting. So if you compare with COLI, I mean, the data set is bigger and more citations and those things. But the important thing to note is both are in English. And I'm going to later tell whatever models we develop, we apply. I mean, those models are sort of agnostic to the legal system, and we test them on both Canadian setting as well as the Indian setting, and they perform well on both the settings. So yeah, we create a UCreate system, which is an event-based approach. It's an unsupervised approach, and very good. I mean, we'll show later. It's a high retrieval efficiency. It's very fast, right, and generalizes very well, right? So let me talk about the intuition first, like the task of event extraction. So if you consider the case document to be sort of a narrative, so it can be represented in terms of the events that are unfolding in the case, right? So by events, I mean sort of a predicate argument structure. So if you look at this sentence from a case, statements were forwarded to the police. If you do the dependency parsing of this, if this case, those of you who don't know dependency parsing, it gives sort of a grammatical relations in terms of these edges between the words in the sentence. So if let's say you have this, so from this you can extract an event like which is I mean the predicate is the verb, right? Forward, and then the corresponding arguments are this subject, which is statement, and then object, which is the police. So this gives you an event for this sentence. So what you can do is you can extract all these events from the case, so that now you have a different representation for the case in terms of these events instead of the text. So this is sort of the pipeline. You have candidate documents and then the query documents, and you extract the events, and then you do some sort of matching of the events between the candidates and the query, and from that you can get certain scores, and then you can rank the candidates based on this score, right? So that's the general pipeline. So so just to give you an intuition, like you have a query document which has been represented in terms of these events, right? I mean, predicate argument structure, and then you have the candidate document, and then you try to do some sort of matching, how many events are overlapping between the two, and based on that you can calculate certain score, how relevant is this candidate for the query document, right? And then we tried lots of different models. We tried the standard count based method like BM25, and then we tried, I mean, the transform based model, and then obviously the event based model, right? So what we saw was that BM25 happens to be a really strong baseline. As you can see, I mean, it was giving around 22 FN score in both the setting, Kohli and the LPCR. However, the BERT models sort of struggle. I mean, they don't give good performance, as you can see, right? And this is what I was telling about. Like, it's not just the semantic, the regular NLP semantics which are important here. There's things beyond the semantics which are really important in this task. And then we tried like different legal BERT and all those things as well. I mean, same. I mean, not much improvement. And then but obviously the event based models were performing much better than all the other approaches. And then you can also combine event based model with BM25 to get even better performance. And then we compared. So this the evaluation metric was F1 at K, right? And you can try out at different values of K, and then we sort of experimented with different Ks on the development set and selected the best one. And the good thing about this, the event-based approach, is that it is much. If you see the F1 score versus inference time, it is really it's highly accurate, but also it is very fast, much faster than the deep learning models or the other BM25 based models, right? So it is sort of a good good trade-off between accuracy and speed, because obviously you would like this system to be fast, right? I mean, if someone is sort of writing a precedent or writing a judgment, they would like the system to quickly suggest the precedents, right? Yeah. So this was the ILPCR task, and then again everything is available, so you can sort of get all the data and everything. So another related task to this is something called ILPCSR. So earlier I was talking about only PCR, which was prior case retrieval, where you try to cite the prior precedents. But now I'm saying, in addition to that, you can also have a task where you want to cite the statutes or the law that should be applicable or which should be mentioned in the judgment document based on the facts, right? So this, and in fact, legal practitioners identify both the things when they're writing the judgment document. But one thing to note here is that there is sort of a dependency or correlation between statutes and the prior cases. So the intuition being that similar cases are going to cite similar statutes, right? I mean, it's sort of obvious, right? I mean, if there is a case about theft, then they are going to cite similar laws, because theft is about, the theft is charged under similar laws, right? So that is the intuition. So that's what we make use of in this joint sort of model, joint prediction of prior cases and the precedents, right? So just to give you an example, like let's say you have a query case, it is citing certain precedents, these two precedents, and it is also citing these statutes. So it so happens that the precedent which it is citing is also citing the same statutes, because as I said, they are about same sort of crime or same sort of thing which is going on. So, if you look at the past work, people have done only the statute retrieval task or prior case retrieval task. And then people try to do statute and PCR, but they were assuming that they were gold statutes were given. What we do is sort of completely from scratch, that there is no gold statutes given. So you want to do both prior case retrieval and statute prediction, right? And then we create the data set and for this, and then yeah, so this is sort of comparison. Maybe I'll skip this part. And yeah, then we tried different models. One was the lexical method. We tried BM25 and event-based approach, which I mentioned earlier, right? And then we again tried bird-based model, and then event GNN, where what we do is we take a triple and create a graph with subject, object, and nodes as the as the nodes, and then edges as the actions, right? Which are sort of the relations, right? And then another model which was para-GNN, where paragraphs are the nodes and they're connected to a single global node, and the rhetorical roles for each of the paragraph is sort of the edge label for that connection, right? So we tried with like these different models, right? And like both lexical and semantic models. So what we observed was kind of interesting. So what we saw that PCR works best in with lexical models, right? Which is like word-based model, and LSR, the statute retrieval, works best with semantic models, right? So these are sort of two different things which are happening here. If you want to do them jointly, then it becomes challenging, right? Because one is about lexical thing and one is about semantic thing, right? So can we have a single method which can do the both? That's the sort of the question that we were asking there. So any guesses? Can we do them together? Any approach? Hybrid retrieval, what's that?
It's like semantic and word level both means like for a word level we are using like BM25 and for the semantic we are using like any semantic method we can use for the retrieval and then combine the both.
But how do you combine?
It's like just in RAG we use like hybrid retrieval system like for the semantic we can use some method like cosine similarity or something like that, and for word level similarity we can use BM25 unigram or bigram.
Yeah, yes, yeah, kind of, yeah. I mean, something similar we tried. What we tried was sort of an ensemble method, where what we do is we try to combine the two and try to balance between the two, right? So what we did was we have some sort of alpha parameter which gives certain weight to semantic score and some, I mean, and complementary weight to the lexical score.
Yeah, exactly. So.
Yeah. So, but this alpha could be either, I mean, determined using some sort of grid search, or you could also learn it dynamically using some sort of
That
feed
means
for.
learning will be more, right? It's like instead of just determining randomly.
Yeah. All right. Okay. Yeah. Thanks. Yeah. So this is what we tried, the ensemble of the two, right? And as I'll show, the dynamic alpha thing approach works better, right? So we tried, yeah, these different combinations of ensemble, right? Event GNN plus BN25, para GNN plus BN, and all sorts of combinations, and this was giving the best performance, right? Uh, yeah, and then so this was, I mean, we were still not satisfied with the performance, right? I mean, it's still not very high. F1 score of 39 is not that high. So what we developed was some sort of re-ranking method. So idea here is that you can use a LLM to select a smaller candidate pool, and then use that candidate pool to refine your search better, and then get a more accurate uh, outcome. So yeah, so what we did was, let me show you this thing. So what we did for the LSR, we get the we take the query document and the list of statutes, just the name of the statutes, and pass it to an LLM and get the top K statutes, right? So this is the top. This one is the top K statutes, right? And that's the phase, stage one. And similarly for the PCR, what we do is we take the query document and then, since we cannot feed the entire candidate pool because it's going to be very super long text into the LLM, what we do is we take each precedent, the candidate, and do a sort of some sort of a pairwise prediction whether this precedent should be cited or not. Like as you can see here, we take the text of the precedent and the query and then give the outcome, binary outcome, whether it should be cited or not, right? 1 or 0. So this gives us this P1 plus. This is the stage one, and then in second stage for LSR, what we do is we take the this the yeah. So the statutes that were corresponding to the precedents which were predicted by the LLM in the first stage. We take those statutes, which is this one, and then we take the standard statutes which were already there, and then we do the sort of prediction over these or the retrieval over these. So that's the second stage for ESA. And then for PCR, what we do is we take the text, I mean, obviously the query text, and then we take the statutes corresponding to the first stage of LSR, which is this, and then the text of the precedent. I mean, again, we are doing pairwise, and then we also take the statutes corresponding to the precedents that was cited by the first stage. And then we do the pairwise thing, and then we get the P12 plus. So it's sort of, we are making use of information from statutes for the PCR and from PCR to statutes, right? So sort of in a pipeline fashion. And this obviously improves the performance quite a bit. Like we go from almost from 39 to 46. That's a huge boost in the performance, right? So this sort of shows that it's sort of not just, you don't have to always do it simultaneously, but you could also do it sequentially, and that gives a better performance, right? And yeah, we did some sort of analysis. Maybe I can skip this part in the interest of time. And we also did some sort of human analysis, and we saw that, I mean, I'll not go into too much details of this, but we saw that the predictions of the model were sort of in agreement with lawyers would be doing, basically, right? So yeah, I mean, yeah, as I said, like we sort of make use of relationship between the two tasks to improve the performance of each of the tasks, right? And again, but I would like to say that here that the performance is still not that great, right? And 46 is not a big number, right? So PCR and statute retrieval is a very, very hard task, and it is really a fertile ground for doing further research. So if anyone of you is interested in this kind of line of research, please feel free to contact me. And again, everything is out there in the open. So yeah, then the other, if you remember in the beginning, I was talking about benchmarks are really important, and that's what we did. We created a benchmark for pushing the field forward. And this is what we call as IL2, Indian Legal Text Understanding and Reasoning Benchmark. And along with this benchmark, we also create a leaderboard where people can download the data set, test set essentially, and then develop their model and give the prediction, and then see where they stand in with regard to the other models, basically, right? And this, so essentially, maybe I'll, so every country has, I mean, different countries have come up with different benchmarks for the legal domain, and this one is, this is the first benchmark for the Indian setting. And then, few things to note here that our benchmark is not just restricted to classification, but also retrieval and other generation and explanation tasks. And the task is grounded in the actual legal workflow, right? It's not, I mean, it's not just some hypothetical tasks which are part of this benchmark. It is actually grounded in the reality, right? And then we didn't develop this benchmark just for LLMs to solve it. It is sort of more generic benchmark. Tomorrow, if some new technology comes and replaces LLMs, the benchmark is still valid, right? And then it's not just in English, but covers 9 other Indian languages. And then and another interesting thing is that it has both common law system as well as the civil law system. Like different countries have different kind of law systems. It covers both, because India has sort of this interesting setting of some laws are sort of kind of common law setting, and some are in civil law setting, right? And then yeah, I mean, maybe I can sort of quickly talk about the design philosophy. I mean, it was to understand, I mean, develop a system. The benchmark should enable development of system which sort of promotes legal understanding and world knowledge. It should have appropriate difficulty level, and then it should not just be in English, multiple languages. Evaluation should be easy to do and more sort of objective rather than subjective, and then it should be publicly available, right? So these are the different tasks that are there in the benchmark. I mean, many of these tasks I've already talked about, right? So I'll just quickly go through. So the legal NER task is like you're given a legal document. The task is to identify 12 entity types in the document. So for example, you might want to find out who's the respondent, who's the appellant, who is the judge, so on and so forth, right? So there are like 12 different labels like or named entities that we want to find out. So we created a data set, and these details you can check out. And then rhetorical role I already talked about. Maybe I'll skip this part. Judgment prediction is another task which I already talked about. Bail prediction I've already talked about, right? And statute identification I sort of already mentioned, right? And then given the facts, you want to find out which particular statutes are applicable. And then prior case retrieval I talked about already. And then this I mentioned. And then summarization task is like you want to generate a gist or the summary of the document, right, which captures the critical aspects of the case, right? So we have another, we had the data set in this thing for summarization, right? And then machine translation task, as the name suggests, is like you're given a document in English, let's say, you want to translate it to regional language or the other way around, right? So this is important for Indian setting because what happens is the district courts are working at regional language, and when a case goes to high court only works in English. So now, right now, there are manual translators, human translators who translate from regional language to English. So if you have a system, then obviously it will help a lot, right? So these were like 9 different languages that we covered, right? Okay, so now the interesting thing is that we tried out different models, and most of them were using bird-based model, and so what is interesting is that we also tried GPT 3.5 and GPT 4. So if you compare GPT 4 result with the SOTA model, most of the SOTA model are based on bird-based model and the other event-based model that I mentioned earlier. So GPT 4 is way behind many of these. So as I said, like a general LLM, general purpose LLM, developed in the West doesn't work for the India, right? So you need some specialized models, right? So everything is, as I said, leaderboard is there on Hugging Face, data set is available. I would highly encourage all of you to please come and participate in the benchmark, right? And then the final part of this talk is about interpretable legal judgment prediction, right? So so earlier I said, like, all these black box models are there, but they don't, they are not interpretable, right? That's an issue, right? So but on the other hand, in the past there have been symbolic approaches like knowledge graph based approaches which offer interpretability, but obviously they don't give good performance. So if it could if you could combine the two approaches, then it's going to be really useful. So that's what we try to do in this neuro-symbolic approach to legal judgment prediction, right? So so, and in particular we focus on something called check bounce case prediction. So check, as many of you might be knowing, is sort of a order a bank, a building, a society gives or a credit union to pay a specific amount from one person's account to another person, right? This many of you might have used, right? And then so check bounce case happens when let's say a person has given a check to another person, and that person tries to withdraw that money from the bank, and it sort of is not able to get that money, right? So essentially the check bounces. So that's where this kind of situation happens. And this falls under something called Negotiable Instrument Act in Indian setting, right? And so why we focus on this is that this is one of the largest financial legal cases in the country. Like there are almost like 4.3 million pending check bounce cases, and it's one of the very common one of the common financial legal cases. So that's why we want to sort of solve this problem. And we first of all need to create a corpus, as always, for this, right? And then we have this task of check bounce prediction, where given the facts of the case, what you would like to do is predict the outcome, whether the decision is favor of the accused, which means he's acquitted, or it's not, or he's convicted, right? So so for this, what we do, we try a different approach. We create some sort of a knowledge graph of check bounce, basically we start with an ontology, check bounce ontology, CB onto, and then subsequently using this ontology we create a knowledge graph, right? And we use LLM along with this knowledge graph to make a prediction, right? So one thing to note here is that what we we discussed this with lawyers, and then they told us that there are certain we examined the Negotiable Instrument Act, and also the one of the prior precedents, which is really important in check bounce cases. And what was observed was that there are certain legal requirements that have to be satisfied for the decision to come, right? And usually judge will look at these legal requirements. There are essentially 5 legal requirements that the court has to establish to come to a decision. So so that's what we try to do. We take these legal requirements and we encode them into an ontology and a knowledge graph. So these are like the 5 legal requirements which have to be satisfied or not satisfied to come to the decision. So essentially what happens is like this. So you are given a check bounce case. You might want to check off each of these legal requirements, and then you will have for each of these whether it is satisfied or unsatisfied. And based on these, you aggregate this information to come out with the outcome of the case. Right? So that's how the check bounce, that's how we model this problem as. So this is sort of the pipeline. First we create the, get the data set, get the documents. Then what we do is we structure the document so that it makes it easier for sort of mapping it to the knowledge graph or the ontology. Right? And for this we use the LLM. We write certain prompts to get this particular structure. And once you have this structured document, what we do is you are given this structured document and an existing ontology, and on the fly you create a knowledge graph, right? And this knowledge graph, along with the LLM, along with the document fed to an LLM, is used to get the decision for each of the legal requirements, which is like a binary 1 or 0 for each of these legal requirements. And then you aggregate these legal requirements to come at the decision. Right? So that's the sort of the general flow, right? And this is what like the ontology, looks like. It's sort of very complicated thing. This we created with the help of legal experts, right? And it took a lot of time to actually create this ontology, which captures the relationship between different entities that are there. And from these ontology, you can actually get the paths for different legal requirements. As I said, like legal requirements are really important. So what you do is you use the ontology and the knowledge graph to get the legal requirement outcome, and then you aggregate those legal requirements to come to the decision. Right? So for example, let's say I have legal requirement 4, right? So, and this is the ontology. So the bold part that you see is the particular path that is there getting activated when you want to, for a particular case, for this particular case, to get the outcome of this legal requirement, whether 1 or 0. Right? So then we tried like different models, both like transformer-based model, LLM-based model. In particular, we tried the Gemini Flash 2.5, and then some open weight models as well. And what we saw was that the models, the neurosymbolic approach actually gives the best performance, and at the same time it is explainable, gives the interpretation, right? So that's what we saw. So this is sort of work in progress. We have done a lot of analysis of this in terms of what kind of explanation. In fact, if you see, we also tried model with explanation, where we asked the LLM to also give the explanation while giving the decision, right? So we compared the explanation of the model along with the decision, along with the neurosymbolic approach explanation, and we see a lot of differences there. Like, those details, we are going to soon release the paper, and then, you can check out those details in that, right? So yeah, so I will sort of now almost conclude the talk, and these are some of the future directions that one could possibly explore. Like, one is, at least in the Indian setting, the documents, as I said, are unstructured. If you can have a system which can automatically structure in some sort of good format like JSON or something, then it's going to be very useful. And then I said, like, legal ontologies, we have just barely scratched the surface. We have only developed it for one particular kind of cases, but developing legal ontologies for the entire legal system is a big task on its own, right? And that is something we should be exploring. And then multilingual legal LLMs is another area. And then things like search engine. And then one of the sort of holy grail would be like as one of you was asking, like a legal reasoning system, right? Like, which can come up with sort of good explanation or new explanation for the outcome, right? So what I feel is that, it's AI community cannot work in isolation, right? So they should be sort of collaborating with the law faculties or law students, right, to work together on this thing, right? And that's what will move the field forward. And just to conclude, I would, I would, I mean, I said, as I said, like legal area is sort of there's imminent need for modernization, right? And even a small improvement can have a big impact because the number of pending cases is huge, right? And then we looked at various use cases in this talk, and then, I mean, there have to be efforts for improving, getting better data sets, tools, and then benchmarks, and still a long way to go, which also means that at least from research perspective, they are really interesting problems to explore and make an impact there, right? So that concludes the sort of the talk on legal AI, and I will also just take 2-3 more minutes to sort of talk about other research areas that my group has been exploring, right? Uh, so so essentially, there are three main verticals in my research group. So one is the NLP vertical, where we have the legal NLP, which I already talked about in detail. Then there is another area is mechanistic interpretability, where we are trying to understand the inner workings of the LLM. If a LLM is coming up with a particular decision, why it is coming up with that decision, what particular circuit is getting activated when that decision is happening, and can you play with that circuit to change the decision, right? So that kind of research we are going. Then there's something called machine unlearning. So the idea here is that, I mean, all these LLMs have been developed on huge amount of internet text, right? And they would have picked up a lot of personal information as well. And there is this law called right to be forgotten, right? And like in EU, there is this GDPR and all those things. So tomorrow a customer can come to a LLM creator or provider that please forget my data. So in that case, I mean, would the provider train the LLM from scratch, removing their data point, or is there a way to actually unlearn that particular small piece of information from the entire data set, right? So that's what this machine unlearning is about, right? And then there are other threads like improving the, there is something called parameter efficient training, PEFT, for fine tuning LLMs and transform based models. So we have developed some new method for that, and then other things like world models, and then clinical NLP and telecom domain and those things. The other vertical is more on the understanding human behavior and decision making. So in this, we have two prominent areas that we have been working on. One is on the affective computing side, where we want to understand the human emotion and the decision making that goes with human emotion, right? So if you have, let's say, a video where maybe 2 or 3 people are talking, so what kind of emotional state are they in, and what is sort of causing that particular emotional state is what we are interested in, and how does that affect the decision making that is going to come out of that, right? So that kind of thing. And then things on like common sense reasoning, because this is really important for models that are going to be deployed in the in the real world, right? So they should have common sense understanding of the world. So there we have been working on like world models, and then things like causal reasoning and those kind of things, right? And then the final vertical is on the social good side, where we have been working on sign language. So the deaf, this is to help the deaf community. So there are around like almost 70 million hard of hearing people in the world, and they face a lot of challenges with regard to communication with the rest of the population. So if you could develop technology which can help them or assist them in communicating seamlessly with the rest of the population, that is going to be of great use to them. So here we have been developing models for translation, sign language translation, sign language generation, sign language understanding, and those four, so on and so forth. So if you are interested in becoming an explorer, want to explore any of these research areas, feel free to contact me. Yeah, thanks a lot. So any questions? Yeah.
Yes, sir. Thank you so much for the lecture. Actually, it was very wonderful and insightful session. I do have two questions. Actually, this is the third time having listening to a lecture in legal AI. So, number one is, how do you guys, I mean, which the gap between AI experts and legal experts? I mean,
Sorry.
how do you convince the legal experts and lawyers?
How do you? Sorry.
How do you convince
How do
legal
you convince?
lawyers? I mean, to jump this with the AI and further. I mean, just is it just an experiment or that you just explained right now? And then that universally transparent with knowledge graph that you just explained in the slides. Is it just the only two things or something else? just to how to the
So if I understood your question, you're saying how do you convince lawyers to work on AI? Yeah. Yeah, that's a good question, and it's not easy, right? But if you show them the benefit of the technology, which will make them more efficient, then they see a reason to invest time in that, right? So that's how you convince them.
yes, I mean the explanation of black boxes is there, and I mean that's with the two different resources with the AI. And the second question is on model reliability. I mean, in a statistical point of view, given from the yeah. Sir, on the model reliability, given the from the data set that I mean, given a 16% data between human accuracy and the base model, 78%, how do you statistically determine on the safety threshold for deploying these tools in real world advantage?
Safety threshold, you're saying?
How
So
to statistically determine this safety threshold?
what do you mean by safety threshold?
Yeah, I mean on model reliability,
Okay, you mean how reliable is the model? Yeah, so yeah, that's a good question. Yeah, that is something we are still sort of exploring. Like if you could see, one idea could be like if you can calibrate, see how calibrated is the model, right? Model calibration could be one way of actually finding out how reliable are those decisions that are coming from the model, right?
and many more can be like this.
Sir, and many?
Many others can be this.
Sorry, I am.
Is this the only one? Or
No, this is one approach. They could be other approaches also. See, the caveat here is that you first need to define what safety is, right? If you can define that, then you can always measure against that particular criteria.
okay, and last question is how do you ensure the high variance across legal categories? That is, if legal criminal versus civil or like tax, how do you ensure the high variance across these categories didn't lead to a distribution that shift to a distribution that shift to a very frequent and less complex case types?
So, okay, you're saying how do you account for variance across different case types?
Yeah,
That's what.
like very legal categories like say tax.
So that's a good question. See, yeah, because see what happens.
And that ensuring that the model does not rely on the less complex and the I mean, more frequent and
Yeah.
legal cases.
So that's a good question. See, uh, as I said, like legal domain is very vast, right? And also a lot of variance is there. So certain cases, like for example, check bounce cases, they are sort of more easy. There's less subjectivity there because there are certain legal criteria which can be used to come up with the decision. But then there are cases like criminal cases which are highly subjective. So that's the nature of the field itself, right? So as I said, you cannot have one model for solving all the different cases. So you need specialized sort of smaller models for each of these different case types, and then you could always, have a system which is, sort of goes in the agentic direction where you could have different agents working on different case types.
Different models are different kinds of things for different legal cases categories.
Yeah, that is a better approach. Yeah.
And also, I was just very fascinated about the symbolic
Sorry, I'm not able
I
to.
am very fascinated about the new symbolic carry approach that you will be using.
Yeah.
And you have been working on progress. Actually, I will about to work on some knowledge stuff. I am actually currently about to work on knowledge stuff with the LLMs and new symbolic AI for detecting detecting the bias in demographic things. Yeah, I was just
Oh,
explaining.
okay, yeah, okay, thanks. Thanks. Any other question?
Hello, sir.
Yeah,
I
yeah.
just want to ask a small question.
Yeah.
Even though the legal expert or judges sometimes disagree with themselves, so how can we expect an AI model to give a good accuracy at judgment prediction?
Yeah, that's a good question. So, yeah, see, the disagreement that is happening is over certain kind of case types, where subjectivity plays an important role. Like, for example, let's say civil cases or criminal cases. So, there, when the decision is coming, it's not just purely based on the law, but also certain socioeconomic factors are coming into play, right? So, for that kind of thing, AI is still not there to give a good decision. But there are other kind of cases, like for example, check bounce cases or banking cases, where most of the legal experts would also tend to agree on similar decision, because there the things are more objective, where you have certain criterias which have to be met to come up to the decision. So for those kind of things, yeah, AI is a really good tool. For other kind of cases, we are still far away from actually coming up with a better a tool which is better than humans.
Thank you for the lecture, sir. So my question was about judgment prediction. So as far as I understand, it predicts the final verdict, and it is supposed to assist the judge, right? Yeah. So what about the prejudice and biasness the AI model will have? Like, will it not affect the final verdict that the judge will give?
Yeah.
Yeah, it is almost like watching a movie after watching its review. So you will have some certain of that biasness, right? So
Yeah, so see that's a good question. So the bias in the model is actually also influence what kind of data is used to train it, right? So if you want to have less bias in the model, then you need to make sure your data doesn't carry any of those biases. So if so that's why if you saw like we sort of try to anonymize the names in the case, and then also temporal correlations were we try to remove those as well. So but there is no guarantee that there would be no bias at all. So I think a lot more research needs to be done to find out what other kind of biases that are they could be possibly there in the model, and then you try to develop techniques which could be sort of de-biased. I mean, it's kind of similar to what you do in machine learning, right? I mean, you have models which are biased, then you try to develop techniques which try to de-bias the model.
okay, yeah, thank you very much.
Okay, thank you, sir, for your lecture. I have one question that what if the AI just started hallucinating in the middle of judgment?
Yeah, that's a valid question, and in fact, that's what we also observed in the prior case retrieval task that I was telling about, the statute prior case retrieval and statute retrieval, where we were using LLM, right? We did saw that LLM was in fact it was GPT 4.1, I guess, which was hallucinating. It was creating certain precedents which didn't even exist. So that is something. I mean, we have to sort of see. I mean, why that is happening, and how do you reduce that hallucination, right? And hallucination is sort of still an open problem in for DLLM. So and with legal domain, it gets even more sort of complicated, because it might come up with certain precedents which might seem very very convincing, but obviously they may not be true, right? So I mean. I mean, we haven't yet explored how do you stop this hallucination. I mean, you could have certain guardrails against it, but there's no still perfect way of reducing these hallucinations.
Okay, thank you, sir.
Okay, thank you.